Hello, it's Lunch with Vince, and I'm here today with Angela. Angela, I don't want to mispronounce your last name. How do we pronounce that?
It's Padlo.
Hadlow. Very good. Thank you for being on, and thank you for wanting to share your story with us. Tell me a little bit about what's going on with you and CPS.
Okay, well, a little background. I am adopted, so of course CPS has technically been out of my life. Um, I was detained from my biological parents, a lot of fighting and all that. But I was adopted by my biological grandmother, who is my biological dad's mom. But the main reason I was detained from my mother was because there was drugs in my system when I was born, and which actually caused me to have fetal alcohol syndrome, which I don't know if you know anything about that, but what that is pretty much brings a lot of challenges, mental, physical, etc. Um, and that, I guess, it does play an impact on my parenting, but just because I have that doesn't mean that I'm unfit parent. I'm in therapy, I'm in mental health, I'm in everything that I need to be in order to get my children back. So that being said, CPS came into my life with my children in 2019. And that was mainly because of domestic violence between my ex and myself, and me allowing my kids to be part of that. And that was incredibly on me for that to be happening. It was a long journey to get them back the first time, and that was mainly because the pandemic hit. So we kept pushing back court. So that was a large uphill battle to get my kids back. And I eventually had to leave my ex in September of 2021 with a restraining order. I just dealt with it too long and too much. And I was like, you know what? Enough is enough. Enough is enough. I need to be away from the situation. I need to do better by my kids. And that's what I decided to do, was do better. And then they were released in June of 2020, of, yeah, 2021. So 2020 is actually when the restraining order happened. I get the days mixed up a little bit. But bottom line is June 2021 is when they were released. And then they were detained again because my, at the time, middle child, she was burned accidentally. We were at my dad's house, and my son had turned on the hot water. I guess he got antsy because I told him he couldn't come out of the bathtub yet because I needed to get his sister out first. His sister's littler than he is. She's one. She was one at the time. She's almost 3 now. But she was burned, and mainly the fact of how she was burned so badly was because we were at my dad's and no one had told us nor him that the water heater was up all the way. And it's a very old water heater, and it burned her. Now my main part was not taking her in when I needed to. Now, I guess in my defense, I did state that it didn't look as bad as it did, because it didn't. It just looked like somewhat of like a bad sunburn. So I know some things to do in when you have like a bad sunburn. So I put cold water on it. I made sure that, no hot water going on, and we wrapped it. And it was maybe 2 or 3 days later, and it just wasn't healing the way it needed to. So we brought her in, and they're like, okay, well, we don't think it's neglect or abuse. We just think it's mainly medical neglect. And I said, okay, yeah, that's on me. And, when my ex had a visit with his biological children, with two of the children are biologically his. So they had a visit with him, and I had found out, referring to the report, it stated that he was not even in the visit, but his mother was. So his mother gave him a call and let him know that there were burns, and he just exasperated the situation because he completely despises me. He doesn't think that I'm a fit parent because he's jealous of who I'm with and jealous of the fact that I moved on. And he's a narcissist pretty much. And he just exasperated the entire situation. And then that caused them to be taken again. And then I recently had a baby with my new partner, and they try to state that there was alcohol in my system. Well, in regards to the alcohol, which is technically the ethanol, which is actually alcohol, there was less than 2% of my system. And I still don't know where it came from, but I think that it came from just because my body was making up for extra nutrients and extra calories because it had to be a C-section. So I couldn't eat for several hours. The last time I could eat was the day before. And so I went in and I did all the fluids and everything else that I needed to do to make sure that, I was staying hydrated before I gave birth to the baby. Well, they stated that I wasn't doing my mental health when there's proof that they've had proof of my mental health since this case started in December of 2019. But I've been in mental health since May of 2019 and on medication since January 20th because I was pregnant with the one that got burned. And they told me that I shouldn't be taking medication because I didn't want to affect the baby. But the medication that I was on when I was pregnant with the youngest was completely safe. And, I'm still on it. I feel like it is a better medication for me. It helps with mood swings. It helps with pretty much everything. And I think that is good to have. And I have taken the initiative to do parenting classes. And I'm actually training to be a special education teacher. So I have all these like little classes that I need to take. So that helps with everything.
So what's going on with you and CPS right now? Are the children in your custody or no?
No, they are not in my custody currently. However, I do have visits with them every Friday, anywhere from 2 to 4 hours. I'm bonding with each individually. I see all 4 of them. They bond with their sister. 2 are placed. So it goes by 2 by 2. So my 2 oldest are placed together, and then my 2 youngest are placed together. So pretty much the girls, and then my oldest and my second oldest are placed together. My second oldest is a boy, so he's placed with his sister.
Okay, I'm going to assume, and I don't want you to say one way or the other, but I'm going to assume your case is in California. I'm going to tell you some things that you need to do in order to get the children back as soon as possible. You don't have to take any notes because this is all being recorded. You can go back and watch this recorded live stream on whatever social media platform you can find it on. I'm looking at our control switch panel right now, and this is being broadcast to 8 social media platforms as we do this simultaneously. Okay, one question before I give you your plan. When is your next court hearing and what type of hearing is it?
It is 2 different court hearings actually, but it's on Thursday. For the other 3, they're trying to state it's termination of services for my other 3, and then for the youngest, it is adjudication and disposition.
Oh, okay. So for Thursday, at the adjudication and disposition hearing, in California, the social worker has the burden of proof. In other words, if you have a trial, which I suggest in most cases you do, you put the social worker on the stand and you examine him or her. Now, in order for them to win the jurisdictional hearing, they have to prove by a preponderance of evidence that the allegations that they've pled in the petition are true. Now, that's a very low burden of evidence, preponderance of evidence. And just to explain to you the differences between the burdens of proof here in California, at the very bottom, we have the preponderance of evidence. And that is what I tell people, more than 50% likely that it's true. So 50.1% is a preponderance of evidence. The next level is clear and convincing evidence. And I tell people that that's like 75% true. Notice the big difference between a preponderance and clear and convincing evidence. Big difference. Social worker has to prove by clear and convincing evidence something. in the disposition hearing, which we'll get to. And then there's beyond a reasonable doubt. And that's what you hear people being convicted of crimes. The prosecutor has to prove beyond a reasonable doubt that you committed the crime. And I say that that's like 95% true. All right. So you see the three different burdens, and it depends on what burden the court is using or supposed to use at each particular hearing. It makes a big difference. I know I talk about this all the time, and I'm not sure it's registering with people, but these are important things that you and your attorney must discuss. So at the jurisdictional hearing, the court must prove, or the social worker must prove by a preponderance that it's you committed whatever allegation CPS is saying. For example, in your case, it sounds like they're using the back history to say that, you're a risk to the child. Right. So notice, I knew that. We haven't talked before, right? And I just knew that from what you were saying about your case, and I kind of deduced where you were in the case and why you were there. But here's the key. This is the real important part. In California, a lot of these courts do the jurisdictional and dispositional hearing together. At the dispositional hearing, the social worker has to prove two things by clear and convincing evidence. Notice I said clear and convincing evidence. The social worker was, number one, prove that you are a substantial danger to the child. Not danger, not a little risky. They have to prove that you're a substantial danger to the child. Do you know how hard that is in reality? And I'm just looking at you, listening to you. I'm not sure they can prove that you're a substantial danger to the child, especially where you have somewhat rehabilitated yourself by taking classes and courses. So even though your other children are in foster care, and you have done rehabilitation, that means that you should probably win. Now, I haven't reviewed your case. I don't know everything about your case, but I hope you get what I'm talking about. And this is something that you should speak to your attorney like today or tomorrow about, right? If your hearing is on Thursday. So yes, you can get that child back, even though the other children are in foster care. All right, because the burdens of proof and the legal tests are different.
Yes.
They may have had enough evidence to start a case on this new child. That doesn't mean they're going to win the case. So, and you can't win the case unless the social worker agrees to give you the child back, which I assume she's not doing in this case. But the social worker is going to have to prove it at a trial. And you and your attorney are going to have a trial. A trial is not your attorney getting up there and just arguing, because legal arguments by an attorney aren't evidence. If your attorney does that, there is a likelihood that you're going to lose. You know why? Because there is clear and convincing evidence against you. In other words, the social worker's report versus you haven't introduced any evidence of your own. The evidence that you introduce could be as simple as you getting on the stand, Angela, and saying, I've done parenting, I've done counseling, I've done domestic violence counseling, I've been in a drug program, I'm testing clean. That's evidence. You testifying under oath to tell the truth, the whole truth, and nothing but the truth is evidence. Additionally, your attorney can cross-examine the social worker. So here's an easy cross-examination of a social worker. Don't write this down, just listen. Go back and watch it later. Social worker, tell me all of the reasons why Angela is a substantial danger to the child. And usually, social worker goes, because I never thought of that. Well, I don't know. And what I really sometimes do is I walk up to the social worker and I ask the permission of the judge and give them a pen and a piece of paper, blank piece of paper. And I tell her, hey, list all the reasons why my client is a substantial danger to this child. And it's like, never gave that any thought. And it's a good way, it's a great way to show the judge that they really don't have clear and convincing evidence that you're a substantial danger. Now, here's the next little trick, and this is forgotten about by many, many people. All right. The social worker has to prove by clear and convincing evidence also, in addition, that there are no less restrictive alternatives to placing the child in foster care. In other words, if they can do something to mitigate the child being in foster care, and they can't prove otherwise, the judge has to return the child, even if the judge thinks that they've proven that you're clear and convincing evidence of substantial danger.
Yep.
You get that?
Mhm.
So here's what I ask a social worker. Hey, social worker, if the child was left with Angela, you or some social worker or some service could go by every day and see the child with Angela. Oh, yeah, that's true. Well, that's an alternative to being placed in foster care. Here's the best one that I like, and I'm, giving my trade secrets here. I asked the social worker, hey, what if Angela's mother lived with her and kept an eye on the baby
Mhm.
while the child was with Angela? Oh, yeah, that would work. Or usually what you get is, oh, I never thought of that. If it's, oh, that would work, or I never thought of that, you win. You get the child back.
Mhm.
Here's another one. Hey, what if Angela's best friend lived with her and kept eyes on the baby and Angela? Wouldn't that be a better alternative than warehousing the child in foster care? Uh, Never thought of that. And you can just, and what I do is sometimes I bring these people to court, and I put them on the stand. And I said, hey, grandma, you willing to move in with Angela and the baby to make sure Angela doesn't do anything to this child? Yes. Hey, grandma, what would you do if something suspicious happened? You'd call the police, right? Yes. You'd call the social worker, right? Yes. That's the less restrictive alternative the law here in California was assuming people would think about. But in many, many cases, social workers don't consider that. Some people says, they don't do it because they don't think about it. They're not qualified. They don't
Mhm.
have the right training. Some people say they don't do it because they make more federal money when they keep the kid in foster care, which, by the way, I believe is true.
Mhm.
But could be a lot of reasons. Social worker doesn't like Angela. F Angela and this kid,
Yep.
right? So there could be a lot of reasons, but those are the two things you got to think about when you're doing a disposition hearing.
Yes.
Do you follow that, Angela?
Yes, I do. And actually, when the baby was first being detained, we had a backup plan that our child was going to go with my partner's grandma. And that was already set up. And then all of a sudden, out of nowhere, the social worker was like, oh, she can't go with her. And we're like, why? And she wasn't giving an actual or an actual answer. She kept saying, oh, it's because she's not trained. She doesn't have this. Okay, here's the thing. She is an RFA certified foster parent and an adopted parent as well. She has my partner's other kid too.
So what you should do is you should talk to your lawyer and bring that person to testify on Thursday. The easiest time for you to win legally is at the disposition hearing. Once you get past the dispositional hearing, it becomes incrementally harder for you to get the child back. All right. Let me answer this question, Angela. Jennifer Ann asks, Vince, do you do Legal Shield? Jennifer, we don't. Many years ago, like 20 years ago, we did. We just fell away from it. But if you call my office and ask for Georgette, she'll try to work out something for you. Okay, Jennifer? Now back to Angela. Angela, now I'm going to talk to you about your other kids that have already been placed in foster care.
Mhm.
This is the first thing that you should do. You should talk to your attorney about having those children moved to a relative or one of your family friends. And the reason is because when the kids are with a friendly placement, that increases the likelihood of you getting the children back substantially. Do you understand what I'm saying?
Mhm.
Substantially. Um, so that's the first thing you should talk to your lawyer about having done. The next thing is I'm going to assume that you're moving towards your first 6-month review date. And the 6-month review date and the 12-month review date here in California is the children must be returned to you unless the social worker proves by a preponderance of evidence that you're a substantial risk. Notice substantial risk, substantial danger. We were talking about the disposition hearing before, substantial danger. Now we're talking about substantial risk. Okay, so it's easier for the social worker to try to keep the child away from you. You can beat the substantial risk evidence that the social worker, tries to use against you by doing something, and that's by completing all the services that your judge has ordered you to do, all the reunification services. And in order to prove that, sometimes you want to bring these service providers into the courtroom so that they can testify. Hey, Angela did my domestic violence class. It was 20 sessions, 1-hour sessions. She was always on time. She always contributed. I feel she learned a lot. Well, what did you learn? Well, in chapter or in class 1, we covered blah, blah, blah. I feel that Angela has internalized that and knows all that kind of stuff, right? Or you bring in the drug counselor, or you bring in the parenting instructor. You get it? The important thing is you bring witnesses to court, all right? If you don't have witnesses, you don't have a case. They're going to be like, screw Angela, she doesn't have a case. But you got to get your witnesses to court. And how do you get your witnesses to court? You subpoena them, right? You make them come to court, all right? And you make them get on the stand. And you blame your attorney for it. Angela, why'd you make me come to court? Oh, it wasn't me. It was my lawyer that made you come. If it was left up to me, you didn't have to come. So blame everything on the lawyer, third party it. Because a lot of these people, they don't want to come to court, right? They have busy lives. They have people and counseling and, other parents to deal with. Who wants to come to court and sit around all day just to testify for 10 or 15 minutes? Not very many people. So those are the things that I think that you should do in order to get those children back. If you want any further clarifications, give us a call at 888-888-6582. Ask to speak to Georgette, and she'll set up something where you can talk to me, or you can talk to my producer. I don't know if you've been emailing with Grace. Grace is the producer of the show, and she also assists me in talking with people. Okay, Angela?
Okay.
Thank you. And again, thank you for sharing with us today. I really appreciate it. I want to thank everyone for watching and posting questions. We'll try to get to some of those questions. I'm taking a lot of questions that people post and I don't get to, and I'm making, YouTube shorts out of them, little videos on our YouTube channel. So I think our channel is called the CPS Strategy Consultant or something like that on YouTube. So go to YouTube and watch all of our videos and our YouTube shorts. All right. Thank you, everyone. This has been Lunch with Vince, and we'll see you folks tomorrow at 12:30 p.m. Hey, if you want to be a guest and you're out there in the audience, contact us. Contact Grace at vincentwdavis.com, or just post on whatever social media site you're watching on, and Grace looks at those comments and she'll contact you and you can be a guest just like Angela, and perhaps I can give you some information that will really help you in your case. Okay? Thanks again, Angela. Goodbye, everyone.
Thank you. Bye, Mr. Davis.